Hi, my name is Abby Larimer. I'm counsel at Ford & Harrison, and I'm here today to talk about Title VII litigation. The purpose of this course is to introduce listeners to the various kinds of litigation that arise under Title VII. We'll discuss briefly some of the background of Title VII and some of the legal developments that have helped shape the law into what it is today. We will also discuss at a high level the various kinds of claims and the general element of each claims. And hopefully listeners will be left with an understanding of the general framework for Title VII litigation. Our learning objectives are to understand the general background of Title VII, understand the types of litigation and causes of action that arise under Title VII, understand the relationship between the Equal Employment Opportunity Commission and Title VII, and educate practitioners on common defenses to Title VII claims. We will also discuss discovery issues that generally arise under Title VII claims. First, we'll talk a little bit about the general background of Title VII. So when we're saying Title VII, what we are referring to is Title VII of the Civil Rights Act of 1964, which was absolutely groundbreaking historical legislation tackling the issues of systemic discrimination in the United States. In the employment context, what Title VII did was outlaw discrimination based on race, color, religion, sex, which can include pregnancy, national origin, and now sexual orientation and gender identity. This was a huge change for employers because the Supreme Court had previously held that Congress did not have the power to prevent discrimination in private businesses. And these were in some cases referred to as the 1883 civil rights cases. An interesting part of the history of Title VII, too, is that initially it was not to include gender and sex as a protected category. Those were actually thrown in an attempt to defeat the passage of the bill, with the thought being that certainly no one would ever pass something that would prohibit discrimination based on sex. But that did pass in the final moments. This is also important in terms of the legal history behind it, because there was not much legislative history to look back to when the first cases regarding sex discrimination were being decided. And so actually there is a quote from Meritor Savings Bank noting that, saying, the prohibition against discrimination based on sex was added to Title VII at the last minute of the floor on the House of Representatives. The bill quickly passed as amended, and we are left with little legislative history to guide us in interpreting the Act's prohibition against discrimination based on sex. And again, that's a quote from Meritor Savings Bank v. Vinson, 477 U.S. 57 from 1986. And this was a case that held actually that sexual harassment could be a kind of discrimination under Title VII, as initially that wasn't, directly written into the Civil Rights Act of 1964. And recently, just last year, this is actually a Supreme Court case from 2020, Bostock versus Clayton County, Georgia. This extended the protections of Title VII based on sexual orientation and gender identity, so expanded what could be a protected class. And in addition to just prohibiting discrimination, it also prohibited illegal harassment based on a protected category. So legally, harassment would be considered a form of discrimination. Additionally, Title VII also protects employees from retaliation if an employee engages in protected activity. This means to complain about illegal discrimination, participate in an employment discrimination proceeding, or reasonably oppose discrimination. And there can be class action legislation or class action litigation, under Title VII, which is certainly less common than your single plaintiff complaint, but it still happens. And who does Title VII apply to? So in the private sector, Title VII applies to most U.S. employers with at least 15 employees, and it may also apply to U.S.-controlled companies operating abroad under certain circumstances.